Hello, everyone. My name is Alex Rushing, and I'm an attorney in Husch Blackwell's Higher Education Group. We are excited to give today's presentation on an overview of current health and safety issues on campus. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to highlight for just 1 minute a few of those key icons. If you have any questions during the webcast, please submit it via the question box. We'll try to answer all the questions during the webcast today, but if a fuller answer is needed or we run out of time, we will touch base with you via email afterwards. We truly appreciate audience participation and certainly encourage you to submit questions throughout. If you have any technical difficulties during our webinar, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Indiana, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Wisconsin credit is still pending. To report your hours in Illinois, Indiana, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. Our recording of the webcast will be available tomorrow for watching and sharing. Once it's available, a link to the recording will be available and emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. Joining me today is Teresa Molyneux. Teresa counsels educational clients conducting Title IX investigations and increasingly common historical misconduct investigations. She advises administrators and staff to ensure compliance and numerous state and federal regulations, including Title IX, Title IV, ADA, and FERPA. We'll get started with our agenda today and begin with first discussing the vaccines, and that's the piece that I'll be discussing. Then Teresa will talk about the mental health issues associated with this topic, and then the student life piece will break up. First, Teresa will discuss hazing, and then I will discuss alcohol and other drugs. So let's dive deep into the vaccine piece of this. I think a big issue related to this topic is that it's viewed as just a K-12 or elementary and secondary education issue, when really it is a higher education issue and something that our clients are seeing more and more come up within their practice and within their college communities. And so that's one of the pieces why we wanted to highlight this during this presentation. It's really important that you balance your institution's interest in community and safety and wellness while still making sure that you're complying with relevant state and federal law. So we'll then talk about what the actual state of the law is. We'll do a little bit of a deeper dive into that. The first piece of it is that the police power of the state has the ability to cause someone or to cause an institution or to cause the state to require vaccines. And you'll see that there's a case site there on your slide. Recently, there's been a lot of heated debate on this topic and the issue of exemptions specifically related to mandatory vaccines. And so that's really where the focus of our presentation is going to go today, related to some of those exemptions. In terms of the state of the law, every state has a law mandating vaccines for its students, but not every state has these two types of exemptions. All states have what's called a medical exemption. That's in every single state. But one of the pieces that's not in every state that we'll look into today, that's in most of the states, but not all of them, are religious or philosophical exemptions. A majority of the vaccine cases that arise in this area are challenging that second piece that I mentioned, the religious and philosophical or personal belief exemption. Some states, as you'll see on the slide, Virginia and Pennsylvania, have very liberal policies with regard to obtaining exemptions for mandatory vaccines. In Virginia, a student, all they have to do is review detailed information about some of the risks associated with the diseases if they choose not to be vaccinated, and they don't have to sign anything, they just have to certify that they've reviewed the document. In Pennsylvania, all the institution has to do is provide detailed information about the risks associated and some of the availability and effectiveness of the vaccines, and then a student can be exempt for religious or any other reason within Pennsylvania. On your next slide, you'll see we highlight some of the more stricter standards in terms of states that do allow exemptions for mandatory vaccines, but they're certainly stricter than the 2 states that we just discussed. So the first one is New York. So they have a somewhat standard religious exemption that allows immunization for students who hold a genuine and sincere religious belief. You'll see that common phrasing used within the case law, genuine and sincere religious belief. So New York has a fairly standard exemption in terms of its language. Minnesota requires a notarized statement that the student has not been immunized because of the student's consciously held belief. And then Texas requires an affidavit in order to obtain an exemption. On the next slide, you'll see that there are 3 states that don't allow religious or philosophical exemptions at all. Those states include West Virginia, Mississippi, and California. This was an area that I was somewhat surprised about to hear. Some of our clients wanted a little bit of benchmarking information about what the various state laws were, just to sort of put in context what their state's laws were. And I was a little bit surprised when I uncovered some of the states that don't allow religious or philosophical exemptions at all, keeping in mind that they do still allow a medical exemption. So that brings us to our first poll question. Does your state have a religious exemption, a personal belief exemption, neither, or you do not know? And we'll wait a second to see those answers come through. I see the answers slowly coming in. We'll wait one more second for the rest of you all to finish with your poll software. Okay, and it looks like several folks are in the I don't know category, which is great for purposes of our presentation. I was a 3rd grade teacher before I became an attorney, so I always like to first check my understanding to see what the basis and the baseline is for my audience. So it's great to see that some of the folks on the line, and a majority, it looks like 53%, don't know where they stand within this area. Some of the folks know that it's religious, or that it's personal belief, or that it's neither, if they fit under one of those states. So here is a map on your screen that really does a nice breakdown of the immunization laws. You'll see if it's that dark blue coloring, that means that your state has a religious exemption, the sort of Husch Blackwell dark blue coloring. And then if it's more of a lighter blue with that line running through it, that's a personal belief exemption state. So obviously each state has its own particular laws regarding exemptions, and it's really important to keep up to date on this issue. This is certainly something that we keep up to date on behalf of our clients for, because it is something that's ever changing and a little bit of a moving target. So you want to make sure that you're obviously keeping up to date on that. One of the other states we wanted to make sure to highlight, because we see we have a lot of folks from Missouri, that's obviously where Teresa and I both practice. We wanted to make sure to highlight Missouri as well. Missouri, the personal belief exemption was not on the map because the personal belief exemption does not apply to public schools and actually only applies to child care facilities. Another state is Virginia. We actually got a question originally about Virginia before we began our webinar, so I'm glad that we're highlighting this state as well. In Virginia, parents can only receive a personal exemption for the HPV vaccine, the human papillomavirus vaccine. And so this is really this highlights how the states are really nuanced in terms of what their approaches are. And so it really is key to keep up to date on this topic and make sure that your policies and procedures are reflecting current state law. This also is certainly a topic that's been in the news. It's not something that has shied away from the news media. It's something that the news media has certainly picked up. In California, on the slide you'll see that we highlighted their Senate bill that went into effect in 2016, or was at least proposed in 2016. And then we also highlighted an outbreak that happened at the University of Missouri's campus in Columbia, Missouri. There were over 340 cases of mumps that involved their students and actually required the university to go a little bit bigger than we typically see, because we don't typically see that large amount of cases of a certain illness like the mumps. And so they actually had to consult their state and national public health officials about that particular outbreak. Measles, you'll see, is a really common issue that causes a lot of this news media coverage, and is one that, related to vaccines, you'll hear a lot about. And so you'll see on the next slide, we also highlighted from New York. This one obviously wasn't within higher education or even K-12 education, but was still something that the mayor at the time, at least within New York, issued a mandatory vaccine in the zip codes related to this particular issue, and that there were no religious exemptions that were permitted, and that if you didn't comply with that particular requirement, you'd receive a $1,000 fine, which is certainly not insignificant. But again, with all of that conduct and that commentary came some backlash and even litigation that resulted from it. So keeping in mind that this is an issue that parents care about, community members care about, and certainly students care about. So here are some things to consider and some key takeaways. You should really be reevaluating your vaccine policies and making sure they obviously comply with state and federal law, but reviewing them when you're reviewing your policies on that sort of typical annual basis, and then also when it receives any news coverage in your local community or even on the national scale. That's where we saw it this past year. A lot of issues for our clients came up and said, this is something we want to look into. This isn't something we've really thought about, but now that it's getting coverage with this other school, we want to make sure we get ahead of it and have a protocol and procedure in place ahead of time. It's also really important that your policies are clear and reflecting the current state law, especially as it relates to religious exemptions or personal exemptions. And this will allow you to limit potential claims or grievances internally and externally, and also making sure that it's readily available. I know some folks don't have their policies and procedures available to anyone outside of the employee, student, or within the community. This is one that you should consider maybe making outward facing, because it does impact not just your sort of physical campus, but could impact a broader area as well. And making sure you're reevaluating your policies on a whatever regular basis. As I mentioned, some folks do it annually and others do it based on when there's sort of news media coverage or sort of a bigger issue at play. And keeping informed of what the particular changes are within your state and within your community is also obviously important. So with that, I will turn it over to Teresa to discuss mental health on campus.
As many of you are aware, mental health issues are on the rise on college campuses across the country, so we wanted to give you a landscape of the law and some best practices. So first, to start off, we have another poll question. I do not need to be worried about litigation against my institution for students' mental health. True or false? And we'll give you a minute or so to answer. Okay, and looking at our results, it seems like the majority of you got the answer correct, which is false. Many courts have said educational institutions have a duty to provide adequate mental health resources and a duty to prevent a foreseeable student suicide, and a failure to fulfill this duty can absolutely lead to liability. So to set a background about mental health on college campuses, it's obviously a major concern not only for students but also for college counseling center directors. 95% of them surveyed said the number of students with a significant psychological problem is a growing concern on campus or in their center. And when students were polled, they said that anxiety is the top presenting concern for them, followed by depression and relationship problems, which counseling centers often help students with. We thought these were some interesting statistics that we wanted to share about what students on college campuses are self-reporting as it relates to mental health. Specifically, 33% of college students report stress-related problems, and interestingly, 33% of college students have also self-reported that they have taken a prescribed medication for their mental health concerns. and 43% of students report that they have felt so depressed at some point in the academic year that it was difficult to function. So obviously this is a huge issue for college campuses and college counseling center directors. Because of the growing issues surrounding mental health, there has been a shift in how campus health facilities have been running. Historically, they were conceptualized as settings where students could be helped through a specific developmental challenge or adjustment problem like homesickness, but now we're seeing that students would like to have long-term health care available through their college campus and have more services and clinicians available to them. So what can higher education institutions do knowing how big of a problem this is on their campus? We know that mental health services play a critical role in promoting healthy and safe campuses, so ensuring that mental health services are available and increasing the amount of clinicians who can assess and manage mental health issues is a huge advantage for college campuses, as strong mental health services improve student retention and the student life experience for students on your campus. And these considerations for what higher education institutions can do can be considered as part of a strategic behavioral health plan campus-wide for students. We also encourage schools to look to federal laws under FERPA and the ADA for making decisions in really complex cases. We wanted to provide you with two different examples of how some colleges and universities are handling mental health availability to students. First, Willamette University, which is a small private school in Oregon, has partnered with Protocol, which is a 24-hour mental health hotline to provide around-the-clock support to students. And the University of Michigan not only has a general campus counseling center, but they also have counselors in what are deemed to be some of their most academically strenuous programming, including engineering, business, dentistry, graduate school, law, and music. It's also important to look to your state laws when determining what mental health services need to be provided to students. For example, in New Jersey, there is a requirement that mental health professionals be available around the clock to assist the state's college students, much like the protocol that Willamette in Oregon is using. So, as always, it's important to stay abreast of your state's laws. Another law we wanted to highlight that isn't in effect yet, but will be on July 1st, 2020, is in Illinois, and it requires that each Illinois public college or university must develop and implement a peer support program utilizing student peers to support individuals living with mental health conditions on campus. Some Illinois schools have already implemented a portion of this programming through additional training for resident advisors to assist students living in residence halls, and other colleges have peer support programs housed in counseling centers or wellness centers on campus. What we thought was particularly interesting about this bill is that no section of this bill can be funded by student fees created on or after July 1st, 2020. Rather, public colleges and universities may seek federal funding or private grants, if available, to support the provisions of this act, and the act is also subject to appropriations. Not only has there been an increase in legislation in this space, but there also has been an increase in litigation. This particular case is a class action suit that was filed against Stanford University in 2018, and the students who filed this suit against Stanford allege that the university has repeatedly violated state and federal anti-discrimination laws in its response to students with mental health disabilities. And the lawsuit states that Stanford students with a mental health disability have been impacted by illegal and discriminatory leave of absence policies and practices arising under the ADA, Section 504 of the Rehabilitation Act of 1973, and the Fair Housing Act. We wanted to highlight Stanford's policy to show what the students are specifically alleging. And at Stanford, there is a leave of absence policy which allows the university to impose a leave if it determines that a student presents a substantial risk of harm to themselves or disrupts the university community. If the student lives on campus, the student must move out of campus housing after a mental health event. The lawsuit alleges that this creates a culture of fear wherein students are afraid that if they reach out to Stanford for help, they will be banned from campus and campus housing. So some best practices for your institution as you are creating policies surrounding mental health and leaves of absence. We encourage you to look at your policy on its face and see if it could be deemed discriminatory, and also look at the effect of the policy on students and ensure that the policy is not discriminatory. Another area for litigation has been related to student suicide. Now, historically, courts have held that suicide was solely the fault of the suicidal individual. However, there has been a shift recently in case law, and colleges and universities face a greater risk of litigation regarding a student suicide. Some parents have brought claims against university personnel based on inadequacy of psychological services or deficiencies of a physical plan, rendering the act of suicide easier to perform.
And one of the things that we learned during our school safety symposium this past year related to student suicide and employee student suicide, related to language associated with it. I think that was a really impactful presentation that we had that talked about how we a lot of times we know to always use person-first language, especially when we're working with students with disabilities, but related to student suicide or employee suicide or that topic in general, being cognizant of the language that you're using related to it, and how the topic of calling it committing suicide is viewed almost like it's a crime. Committing murder was like the analogous language, that's what a student hears, that it's somehow criminal what's taking place. And so being cognizant of the language that we're using when we're talking about the issue of suicide is something that folks that are in that community that are advising students on a day-to-day basis in terms of their mental health are very cognizant of, but making sure that administrators and staff and employees are cognizant of it as well is really important.
Absolutely. And we wanted to highlight a few specific cases in which these issues have arisen. This first case with MIT involved a graduate student, and in this case the court held that universities indeed have a duty to students to take reasonable measures to prevent suicide if the following circumstances are met. First, the university has actual knowledge of a student suicide attempt that occurred while enrolled or recently before matriculation, or if a student states plans or intentions of committing suicide to university personnel. In this case, the court held that the university dean did not have a special relationship with the graduate student that required the university to take reasonable measures to prevent the student suicide because the duty hinged on foreseeability, and the court ruled that it was not foreseeable, in particular to the university dean, that the student would attempt to commit suicide. But a finding of a duty is heavily dependent on the facts, as we'll see in the next case, also involving MIT. This case was with an undergraduate student who had a history during her time at MIT of suicidal threats and cutting herself, and the parents filed a claim of gross negligence against the university's medical professionals for failing to deal with the immediate threat. And we will see that the court concluded that MIT in this case, by not formulating and enacting an immediate plan to respond to the student's escalating threats to commit suicide, the parents survived summary judgment and had put forth sufficient evidence of a genuine issue of material fact as to whether the department was grossly negligent in the treatment of the student. And typically when a court finds that a duty exists, which again is very state law dependent, several factors are considered under foreseeability, including actual knowledge of an attempted suicide, failure to give notice to the right parties, including parents, clinicians, hospital staff, and failure to make or initiate protocol on campus for suicide prevention. So with that, we'd like to provide you with some best practices for your institution. We encourage students to have the ability to talk with mental health professionals and make sure that there are plans in place if they suggest to these mental health professionals that they are contemplating or have attempted to commit suicide. And we encourage schools to develop a student suicide prevention protocol, a student suicide attempt protocol, and a protocol for when they know a student may be suicidal. And we also encourage universities to maintain mental health resources, not only for students, but also for staff and employees.
And one of the things that is interesting in this area that frequently comes up is the nuance within those mental health resources that are available. Looking at confidential apps on your cell phone, all the way through that 24-hour hotline that Teresa mentioned earlier. This is one area that so much of technology is changing and providing resources related to this issue. It's not just something that impacts students or employees, it impacts everyone across the country. And so this is an area where we're seeing a lot of development within technology, and so keeping up to date on what that is and what those even free resources are to provide to your students and your community members is really important.
Absolutely. And with that, we're going to transition into our next section of student life. We will focus on two major issues under the student life umbrella, including hazing and alcohol and drug use. So first, with hazing, many of you on the phone are familiar, but hazing refers to the practice of rituals, challenges, and other activities involving harassment, abuse, or humiliation used as a way of initiating a person into a group, such as fraternities and sororities, sports teams, and bands. Even though hazing has been widely condemned, hazing persists on some campuses and creates a substantial risk of serious injury to students and a substantial risk of litigation to the institution. We wanted to highlight for you just the amount of news coverage that has been shown recently about hazing on college campuses, and it continues to persist and is a reality for most institutions as seen by these headlines throughout the country. This is a map about state anti-hazing laws. Each state in red does not currently have anti-hazing laws in place, but each state in purple does. For example, in Kansas, there is a requirement that if hazing is found, it is a Class B non-person misdemeanor. In Tennessee, there are institutional penalties that may be imposed by the IHE if hazing is found on a college campus. And Missouri law states that the offense of hazing is a Class A misdemeanor unless the act creates a substantial risk to the life of the student or prospective member, in which case it is elevated to a Class D felony. That brings us to our next poll question. Does a university have a duty to protect students from hazing activities? Yes, no, or sometimes? Okay, and here are our answers. 73% say yes, and 26% say sometimes, and we agree with the 26% that it is indeed sometimes. A special relationship between a student and the university can arise, creating a duty, but this is extremely dependent on the facts of the particular case, the law in the jurisdiction, and especially dependent on the university's actions taken to reasonably decrease the risk of harm to a student. So we're going to dive a little bit deeper now into the law surrounding hazing. Now, generally, there is no duty for the part of a college or university to control its students based merely on the university-student relationship. In the past, colleges and universities have successfully avoided liability for hazing-related injuries based on the no-duty rule, which states that the relationship between a college and a student is solely educational. However, courts have now found that where there is direct university involvement in and knowledge of certain dangerous practices of its students, the university cannot abandon its residual duty of control. Now, though, if a duty is found, the plaintiff must prove that the institution's breach of duty caused the injury. We wanted to highlight for you a few cases in this hazing space that colleges and universities should be aware of. The first is Morrison via Kappa Alpha Psi fraternity, in which a university student brought an action against the institution for damages resulting from hazing activities. In this case, the court found that because of the prior knowledge and serious nature of hazing, the social policy justified a special relationship between the university and its students in this particular instance. The court found that this special relationship created a duty on the part of the university to the student. Furthermore, the court stated that under these circumstances, universities that allow and regulate fraternal organizations have a duty toward their students to act within reasonable bounds to protect against illegal hazing. Now, the court noted in this case that the university, in spite of its knowledge that members of the local fraternity were possibly hazing, that the university did not follow its own procedures for investigating or remedying such a problem, which is very important. Colleges and universities have policies and procedures in place, and they need to be followed and implemented consistently. And the court found that because of this, the record helped support the jury's determination that the university's failure was a contributing factor that made it possible for the student to be physically hazed. And the state's failure to thoroughly investigate the prior complaints of hazing also led to the possibility that this particular student that brought the lawsuit could be hazed by the fraternity. A more recent case comes out of Louisiana State University, where a student died in September 2017 following a fraternity-related hazing incident. What's interesting about this case is the parents brought a lawsuit against LSU under Title IX, stating that LSU was deliberately indifferent to the great risk of injury and death to male Greek students and failed to investigate hazing. The lawsuit compared fraternities and sororities on LSU's campus and stated that male Greek students at LSU have entirely different and unequal access to educational opportunities. The plaintiffs in this case, the parents of the deceased student, argued that fraternity members and fraternity pledges at Louisiana State University are far more at risk than their sorority counterparts because the university disregarded the dangerous and sometimes fatal hazing activities that occur among men in Greek life and cracked down on sororities with alleged hazing violations much more severely than they did the fraternities. And the U.S. District Court of Louisiana agreed with the parents and denied Louisiana State University's motion to dismiss. An appeal was filed in this case on August 19th, and we will keep you abreast as this goes through the appellate court to determine whether this is a cause of action under Title IX. To finish up the hazing portion, we wanted to provide you with some best practices surrounding hazing that could occur on campus. First, as we have discussed in depth, it is very important to develop policies and procedures in advance of those incidents and follow them. We encourage our clients, after developing policies, to ensure that there is appropriate and yearly training for employees specifically regarding these hazing policies. We encourage our schools to do this right around sorority and fraternity recruitment to ensure that these policies are top of mind for the individuals involved before this starts. Also, we encourage an immediate and consistent response to hazing allegations or injuries, much like the LSU case highlighted, where sororities on LSU's campus were treated more severely and harshly about hazing incidents than the fraternities. And finally, we encourage you to work with your counterparts at national fraternities and sorority organizations and be proactive in talking with them, explaining your college or university's policies and procedures, and getting the national organizations involved should any incidents arise, and create a partnership to help you navigate not only the investigation but also how to respond and handle hazing allegations. And with that, I will turn it over to Alex to discuss alcohol and other drugs on college campuses.
Thanks, Teresa. So one of the pieces that we've had a couple questions come through about relates to how to best get this communication out there, and we'll dive deep into that related to alcohol and other drugs in this section, but I'll answer that question now. And I think training is a big piece of it, but making sure that it's not just that annual legal update training, that there is periodic training offered, or that there's other opportunities like this one that we're presenting that are offered to your campus community is a really nice touch, I think, in terms of making sure that the right people are hearing the information and that the depth of information that's covered is impactful, especially in these areas like alcohol and other drugs, like mental health and like hazing. That's sort of the thread that you'll see throughout our presentation, is making sure you've got great policies and procedures, that you're applying them consistently, but that you're also training the folks who are really on the ground administering the policies and procedures is really important, especially as it relates to the topics we're covering today. So with that, I'll start with our alcohol and other drugs topic. So obviously, you'll see on this slide, alcohol use is not a new or innovative topic within the higher education community. Alcohol use has frequently been associated with college campuses, and certainly binge drinking, we've seen statistics rise over the years in terms of reporting. A lot of what you'll see in terms of the statistics on our slides are reported information, and we see an increase in reporting related to these topics. That doesn't necessarily mean that it's happening more often, but instead that it's just being reported more often, which I think is a great thing. The fact that you know that it's happening on your campus is really the critical piece, not that it's happening more frequently as it appears. I think the incidents of it being reported have just been really increasing. So you'll see some really important statistics on this slide. 32.4% of college students report binge drinking, which is defined as 5 or more drinks in a row in a short period of time during the past 2 weeks of the study that was conducted by the National Institute on Drug Abuse. And so that number is, again, those students who are reporting it, not only reporting it, but are reporting binge drinking and reporting doing it within the past 2 weeks. This study was taken during the school year, so it wasn't during the summer months or anything like that. This is a fairly accurate representation of what a student is feeling now during the semester. And then 40.8% of college students reported having been drunk in the past month, again, from that National Institute of Drug Abuse and National Institutes of Health, that survey that was conducted in conjunction with the U.S. Department of Health and Human Services. And that study was conducted in 2016, and so those numbers are not far off from what is probably readily available now, and that's obviously the current up-to-date information. While drinking is something that I think a lot of administrators and employees are familiar with in terms of the student misconduct and student conduct issues associated with it, one area where we see a little bit less of an understanding is related to drugs on campus. And this topic, we'll discuss both illegal and then prescription drug use in a moment. But marijuana use is the most frequently thought of in this area, and it's something that its use has been at the highest level since the 1980s for this particular age group that's currently in college, that 18 to 22 age range. These statistics are much lower, as you'll see, than what you probably think of in terms of drug use on your campus. Again, this is in part because marijuana use is illegal in most jurisdictions, and so the amount of individuals who feel comfortable reporting this to a federal agency is probably lower than is actually accurate. And so making sure that you have a good pulse on your institution is critical with this particular area. Amphetamine misuse. appears to be higher in college students than their non-college peers. So this is obviously another area that it's really important to keep a good close eye on in terms of training, not just your administrators, deans of students, things like that, who are dealing with the misconduct piece of it, but also your RAs when they're going in and doing investigations or talking to their residents on their floors. This is an area that I think there is a gap in terms of training and making sure that the RAs know how to properly assess those situations as they come up, because it will only be increasing as the laws continue to evolve and change. You'll see again these statistics on the screen related to Ritalin. 2.4% of college students report that they use at least Ritalin part of the year. And Adderall, you'll see, is almost 10%. Again, I think that number is much higher. I think that in part some students who use both Ritalin and Adderall are using it on a non-prescription basis, and therefore would obviously make it an illegal drug use. And so making sure that you're up to date on policies and procedures of how to implement issues related to student misconduct in those areas is really important, as well as providing resources on how to get help in these areas. The newest threat as it relates to this alcohol and other drugs, or AOD topic, is one that relates to prescription drug use. And you'll see a lot of staggering statistics. I think it's important to put numbers associated with it. That's why I've highlighted that in a lot of these slides. The other thing to keep in mind is these are obviously national statistics. The statistics on your screen right now come from the Campus Drug Prevention Organization, and these relate to statistics from 2018 based on a study that was conducted at that point. It's really important to look at the numbers on your campus too, and keeping track of the amount of complaints or issues arising from these areas on your campus. The numbers, as I've said to my clients, sometimes numbers never lie. And that's an area where making sure to know what your campus statistics are, how your community is on this sort of scale in terms of where you all fall is really important. And so keeping that in mind as you're sort of looking at these statistics. You may not be capturing right now how many issues you have related to your students, nor are you probably doing studies to see whether your students are using or misusing drugs or alcohol, but keeping in mind sort of the amount of misconduct that's happening and tracking that to see if there is a gap in training or a gap in understanding that you can somehow prevent that from happening. So you'll see 16% of college students said that they believe it's somewhat easy or very easy to obtain pain medication for non-medical use, again, non-prescription, illegal use in that instance. 20% of students in this 2018 study found that sedatives are somewhat easy or very easy to obtain. Again, these were the categories that they were checking the boxes in. And then a majority of students who misuse prescription drugs reported that they do obtain prescription drugs from their friends, oftentimes from their peers within the college community who are also students or are also members of that larger community. So 51% for pain medications and 57% for sedatives and 79% for stimulants. We had one question come up related to the Drug-Free Schools and Communities Act of 1989, and so I'm glad that question came up. But in part, we didn't answer it because we knew it would be able to cover it during this piece of the presentation. So institutions who are receiving federal funds, which most of you are, the vast majority of you are, have to certify to the Secretary of the Department of Education, the U.S. Secretary of the Department of Education, that you've adopted and implemented a drug and alcohol abuse prevention program. I'll refer to that as a DAP here. That's just one of the areas of my focus is alcohol and other drugs, so occasionally I'll speak in this acronym concept, and so I try to not do that as much to make sure, in case for those of you who are on the call that don't handle these issues as frequently, know what I'm talking about. But if I do get into the alcohol and other drugs speak, I apologize, and that's what I mean when I say DAP. I mean the Drug and Alcohol Abuse Prevention Program. And so that program must be designated to prevent the unlawful use, possession, and distribution of illegal drugs and alcohol by students and employees on campus or any school-related functions or activities. This area covered by your DAP is not just the campus. I want to make sure to highlight that, but it also includes fraternity or sorority houses that are not on campus, but are officially recognized by the institution of higher education. So that's really a key piece within this. Some folks think that it's the physical location of the campus, but it's really what's recognized by your institution. And so that's going to bring us to our next poll question, which is really important for those of you who are in some of the CLE states that require you to respond to our poll questions. We want to make sure you get full credit for your participation today, and we really appreciate it. So make sure you're answering these questions. If an institution posts its DAP information online and informs students of its location, does it still comply with the Drug-Free Schools and Communities Act of 1989? Yes, no, or sometimes. And we also gave you the option of I don't know if this is an area that you're a little bit unfamiliar with. I expect all the lawyers on the call are weighing their options of yes or no, but may ultimately go with sometimes. So we'll see where everyone ends up. We'll give you a few seconds to answer that question. We see a few more answers trickling in, so we'll give another second while everyone's weighing their options. Okay, it looks like we're sort of spread across the board, which is great. It means that it was a good question. I'm excited about this one. So 17.3% of you said yes, that if your institution posts your DAP information online and informs students of its location, it still complies with the Drug-Free Schools and Communities Act. 28% of you said no, that it doesn't, that wouldn't comply. 20% of you said sometimes. I'm guessing we've got 20% of you are lawyers on this call. And 34% of you said I don't know, so I'm excited to be able to teach you this information. The answer is sometimes. Maybe that's because Teresa and I are lawyers, so we purposely chose a question that ends in the answer sometimes. But in this one, the nuance that I want to highlight is institutions of higher learning must send all students and employees all of the information about the DAP listed in the earlier slides. That's obviously something you all likely understand. But sending an email or other document that just provides a link to some of the information or to other broader school policies is not sufficient. Providing just a link to it isn't enough, and I think that's where the nuance within the information about what you're actually informing your students about and your employees about, it matters in this instance, because providing just a link, which some of the folks maybe on this call have done, isn't enough and could actually result in fines. This is an area we have seen that the Department of Education issue fines related to, so it's really important that you're not falling under that category of schools that just send a link out. So here are your 5 DAP elements that really have to be included and assessed every single year and have to be part of your DAP, obviously. Making sure that you've got a standard of conduct that clearly prohibits possession, use, distribution, all of those things of illegal drug and alcohol use. One of the pieces that I want to highlight within this relates to having a list of applicable legal sanctions under federal, state, and local laws. Having those legal sanctions listed is really important. One of the things that is changing, and I see we have a number of folks from my home state of Illinois on the call, starting January 1st of 2020, Illinois residents age 21 and older may legally purchase recreational cannabis and possess up to 30 grams of cannabis flower. The possession limit is 15 grams of cannabis flower for non-Illinois residents. And so that's one of the pieces where within the applicable legal sanctions under federal, state, and local laws, that is something that you all will have to be changing if you're in Illinois starting January 1 of 2020 within your DAP, making sure that you're including that language because that is a big change. At our firm, we have a huge group that practices in the cannabis space, and so it's great to be able to partner with them in some of these areas that cross over not just on the corporate side, which is typically where they handle it, or sort of advising based on financial funding and things like that, but how it crosses over into the higher education space has been really nice to have their expertise combined with ours to really be able to assess these issues for our clients, especially as the laws have been changing. We knew the Illinois law was potentially going to go into effect, and so we were at the ready for it if it did, and now that we know that it is going to start in this upcoming calendar year, it's really important to make sure that your notices reflect that. You also have to have a thorough description of the health risks for use of illegal drugs and alcohol, making sure that also is very user-friendly and readable for your student population, making sure it's not too complex. That's an area where I think sometimes cutting and pasting can get the better of us, and so making sure that really is catered to your university community and your institution. The fourth element is to provide a list of any drug and alcohol-related prevention programs that are available to students and employees. This is the area that I see a lot of times where folks have so many resources and so many programs available, but aren't accurately capturing it within their DAP. So we want to make sure your DAP reflects what's happening on your campus and the great things that you're doing related to preventing alcohol and drug use on your campus and resources available for your community members. So making sure that it's consistent with what's going on the ground. Number 4 is one of those areas I think sometimes you'll just use the same language you use every single year, and making sure that actually reflects what's happening is important. The final piece is a statement affirming that your institution of higher learning will impose disciplinary sanctions for violations of the standard of conduct. So making sure that your standard of conduct is in there, but also having that language that your institution will impose disciplinary sanctions. And this is an area that the U.S. Department of Education needs to see, and so you need to make sure that is certainly reflected within your DAP. The next piece we'll dive into is the notification requirement. And so this is where, as we talked about with our poll question, you have to ensure all students and employees are annually notified of the DAP information that we've been talking about on all these previous slides. Making sure it's not just a link for them to access it, but that they're actually provided with a notice of the information. It's really important that it's not just that link. Making sure that the delivery of the information comes from the appropriate team members. This sometimes requires a little bit of coordinating, maybe sometimes within the general counsel's office or in the dean of students office, to make sure all the different departments have the information and that it's reflected within their groups. So making sure to have a coordinated effort is really important. That's the focus of that second bullet point. And the final piece on this slide in terms of notification is making sure that you all understand that this doesn't just apply to full-time students. I think most would assume that it applies to full-time students, but it does apply to part-time students. And for those of you who have online programs and more commuter campuses or non-housing focused campuses, it's really important that this applies to all of your students. It doesn't just apply to the traditional four-year institution full-time attending student. It applies to all students. The next piece relates to your biennial review and updating your DAP. This has to occur every 2 years. I think sometimes when we use the word biennial or biannual, we don't know if we mean twice a year or every other year. And so in this instance, I wanted to make sure we all knew it is every 2 years. It's every other year that you have to assess this. And this slide covers the minimum of what your review should include, and this is sort of the minimum of what someone should be assessing, either your in-house counselor or outside counsel is assessing. But this is a minimum. This is the sort of bare bones. This is certainly not, when we're assessing these issues, we go into much deeper dives in terms of these issues. So making sure that this slide is sort of used as the baseline as opposed to what should only be covered. Making sure that you're looking at a description of the research and data analysis used to determine the effectiveness, identification of the officials or the offices that are responsible, making sure that those are up to date to the extent folks are changing offices or that officials change is really important. That you have detailed measures on measuring your DAP's effectiveness and the consistency of sanction enforcement. Teresa touched on this in the hazing side of things, and that was great, but making sure it also relates to the drug and alcohol enforcement is really important, and seeing that it's consistently applied regardless of any of those protected statuses, that the policy is being implemented appropriately across the campus. And then a description of how the findings of the review will be used to improve the effectiveness, this sort of narrative description, making sure that that's covered, and then obviously the signature of the institution's president or the governing board that ultimately ends up approving that report, obviously making sure that that's done. Again, that's the bare bones minimum. So we'll leave you with, in terms of updating your AOD policies, this time of year is very frequently when folks are having more and more college students on their campuses and starting school and realizing how frequently they're turning to it. This is the time where I love when my clients will say, this is a great policy, I like it for now, but I'm seeing issues in this area. Please, can we talk about this during the fall break or during the winter break or during the summer break? Highlighting those issues right now as they're happening in sort of comment form on your desktop or however you sort of keep your policies and procedures. That's really helpful for us as outside counsel to make sure that what we have in your policies is actually what's happening on campus, and then also revising it to reflect best practices and reflect what your university or your college community is requiring or demanding. That's really important as it relates to this policy because, like I said, it's an ever-changing area, and you have to make sure you're keeping up to date on it. And also subscribing. I'll do a little bit of a plug for our legal alerts. This is something that we frequently will issue legal alerts on, as will our, like I mentioned, our cannabis group. They will also issue legal alerts related to these topics. So keeping up to date on that is obviously really critical. And so we only have a couple seconds for questions. And I see some of the folks who have asked questions. I think we've covered a little bit throughout the presentation. We tried to do so throughout our presentation. One of the areas related to mental health resources and sort of where we were coming up with our statistics on some of our citations and other areas. And so I'll turn that over to Teresa to comment on that.
Yes, thank you for the question. So the JED Foundation, which is headquartered in New York City, is a nonprofit organization that focuses on high school and college students and protecting their emotional and mental health and preventing suicide within those populations. And they have done multiple studies to determine the specific things that students are self-reporting and self-identifying as particular issues that are arising for those populations. Also of note is that JED will partner with high schools and colleges and can do trainings regarding mental health, substance misuse, and suicide prevention programs. So it's a great foundation not only for benchmarking with what students are self-reporting our issues, but also in helping in that prevention piece and helping with college programming to help your student population.
One of the other questions that came up was related to the marijuana use and that it's still a Schedule I narcotic under the Controlled Substances Act under federal law, and whether schools still have to forbid it on campus even in states where it is legal under state law. That is accurate, but making sure that you're also within your DAP, you have to have a summary of for example, in this instance, the Illinois compiled statutes, because Illinois is the most frequent or the most new state to change their law in this area. Making sure that reflects what the criminal penalties are associated with it or lack thereof. And so one of the other folks asked for me to repeat that piece. And so starting January 1st, 2020, Illinois residents age 21 and older may legally purchase recreational cannabis and possess up to 30 grams of cannabis flower. The possession limit is 15 grams of cannabis flower for non-Illinois residents. Making sure that summary of the applicable state and local laws are in your policies, regardless of whether you enforce it in terms of university policy, is really important. And so we'll flip to our last slide, which just has our contact information. If you have any questions or follow-up, obviously Teresa and I are both available. We're based in the St. Louis office, but certainly advise clients all across the country, which is our honor. And so with that, thank you for joining us for our program today. We hope the information provided was helpful for you and your institution. If you have not already done so, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback does assist us in providing quality future programs, especially as it relates to what programs we should submit in the future or provide for you in the future. As a reminder, this program has been approved for Colorado, Illinois, Indiana, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Wisconsin credit is still pending. A recording of the webcast, as I mentioned, will be available tomorrow for watching and sharing. We encourage you to share it with your colleagues. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. Please be sure to join us for our next webinar on September 25th, which is a deeper dive on fraternities and hazing. This concludes our webinar. Thank you.